Good morning, everyone. My name is Jack Ryan. I'm the Chief Administrative Officer here at Rockefeller Capital Management, and I am thrilled to welcome you to today's presentation, in which we will dive into important planning considerations as we approach changes to the current estate and gift tax exemption amounts. With us today, we have 4 of our domain experts who definitely know their stuff, and equally important, are excellent at simplifying complicated topics and executing sophisticated strategies for the benefit of our clients, their families, and generations to come. With us today, Jason Thompson, who is our Chief Wealth Strategist, Lisi Madden, who's Head of Fiduciary Services, Tim Laffey, Head of Tax Policy and Research, and Katherine DiSalvo, Senior Trust and Estate Advisor. Each of them deals with these issues on a day-to-day basis within their respective business lines and plays a key role in helping to implement the strategies you'll hear about today. On a personal note, in partnership with my private advisor team, they have helped my family immensely, and I know they will help yours too. So with that, let's get things rolling, and I'll turn things over to Jason Thompson.
Great. Good to be here. Thanks so much, Jack. Listen, let me just queue up we put some bio information in here for everyone, and it's a rather sort of meaty deck in terms of content, and we'll send it out to the audience later, but let me just queue up my portion of it. Well, listen, I want to talk about a few things. These are the conversations that we're having with clients on a daily basis. So really my charge is to cover about 3 different topics. Well, I want to talk about core estate planning documents. So at the end of the year, it's usually regular conversations throughout the year, but particularly at the end of the year, we're talking with clients about whether their estate planning documents make sense. Are there the provisions that we would expect to see for someone at a given net worth level, for someone at a given familial makeup? So we'll talk a little bit about what that entails and what are the provisions that we would expect to see. We'll talk a little bit of tax. So get the coffee on and get the Red Bull sort of going. We'll talk about where the law is, talk about where the law is going. And then the third part, how do you kind of plan for that? What is the opportunity given where we are from a tax standpoint and where we know as of now where the law is going to change in a couple of years? So let's dig into those few things. So listen, I just wanted to kind of talk about why a basic estate plan is important. I think many of our clients have estate planning documents, but they can be a few years old, or they can be 5 years old or 10 years old or more. It can be a bit of a eat your vegetables exercise to have a look at your estate planning documents and kind of review all those things. But there's a few good reasons, and we'll just kind of pick some things here, and I'll probably take them in reverse order. A basic estate plan does a few different things. Most importantly, I think, as most people note, is where are my assets going to be distributed? So what are the assets that I have? How are they going to be distributed? How are my assets titled? If we have a married couple, how are they titled during life? What happens when one spouse passes away? Certain structures should spring to life. And maybe if both spouses pass away and assets go down to the kids or grandkids or other heirs, how should they go? Should they go outright? Should they go in trusts? What are the provisions of any trusts where assets may go into? So it's very important to say this is your global thinking, typically with your basic estate plan. How do I want my assets to flow and how should they flow? Second point for the bottom, who are the guardian of my minor children? So my wife and I are married. We have 2 young kids, Jack and Benjamin. They're 5 and 7. Your documents are going to name who takes legal custody of the kids if you happen to not be able to take custody of them. So if something happened to my wife and something happened to me, who is the guardian who's going to step in and take legal custody? And then also you'll have a successor guardian as well. So what does that look like and who are those people and do they still make sense in your documents? Who's going to administer your estate, right? There's going to be executors, there's going to be trustees, there are going to be key people with fiduciary important responsibilities in your documents. And do those people, are they named? Are they the right people who should still be named in your documents? Because I think people's wealth changes, the makeup of their wealth changes, the law changes, people move in and out of your life. So are the key people that should be named in your documents, do they still make sense? We have a lot of clients who are business owners, whether they're real estate or pick your variety of closely held business. What's your succession plan look like? or your shareholder documents and business documents coordinated with your estate plan. And then we talk a little bit about covering estate taxes, buy-sell agreement. If you happen to have a closely held business, how are we going to cover any estate taxes if they're due? So this is all to say that there's a lot that goes into an estate plan. And I kind of want to hit the main documents one by one, just to talk about what they do, give a bit of an overview to level set us. So listen, the most famous of estate planning documents is the will. Some clients have a will. It's usually a will and a revocable trust. We'll talk about the revocable trust in a second. But a will is going to do a number of things. So no matter what, you're still going to have a will. Number one, I'll take the middle point because it's important, because I have young kids and I know a lot of people out there do have young kids. It's going to name the guardian, who's going to take legal custody of the kids. It's going to name your first person, then you'll have either one or two successors. So if first person is unable to serve, you'll have another person named in there as well. I can't tell you the conversations that we have on a regular basis where that person doesn't make sense anymore. Or maybe the first person does, but the successor guardian doesn't make sense. So perhaps the most critical thing that your documents are going to do, certainly your will, it's going to name a guardian for any minor children. Second, down at the bottom, it's going to distribute actually your assets. Importantly, it's your probate assets. So just a quick point that not all assets are going to be controlled by your will, right? These are just probate assets that are going to be controlled by your will. So think about things that are non-probate assets, which is just as important. IRAs, right? 401ks, annuities, insurance, anything that is jointly held. So there are some assets that are going to pass by operation of contract or operation of law, right? Somebody who's on that beneficiary designation on your IRA, that's where the asset's going to go, or on your 401k, or on the insurance, or on the annuity, despite what your estate planning documents say. So it's important to have a look at not only what your documents say, but there are some things that are just not going to be controlled by your will or your revocable trust, and you need to have a look at those as well. Or maybe the property is jointly held with right of survivorship. A fundamental tenet of a property held joint tenants with right of survivorship is that it automatically goes to surviving joint owner. So how assets are distributed at wealth, your will is going to take care of a lot of those assets. And I want to know who they're going to go to. I want to know whether they're going to go outright. I want to know whether I'm going to send them in trust and what are the provisions of that trust. So critically important in terms of where your assets are going to go, how they're going to go, but also note that your will isn't going to control a lot of your assets. Some of the other things, there's a beneficiary designation where you need to make sure if that makes sense. And then kind of our top line there, it's going to appoint an executor as well. So depending if you just have a will or the complexity of your estate, this can be a really big deal, right? I mean, this is who's going to take legal responsibility for administering the estate. And again, a lot can go into that. So I think this person needs to be, they don't have to be the most, I say, financial savvy person, but they need to be some level of organized, right? They need to know what the job is, and they need to know who to bring in if they need to figure out how to notify banks or notify creditors, or they're representing the estate in probate court. They're filing the final tax return. They're literally distributing the assets. So depending on what the variety of the estate is, there's a lot that can go into it. But these are the three components, really, that your will is going to take care of. So for most of our clients, they're going to have a revocable trust. So everybody's still going to have a will, and it's still going to take care of personal property, and it's going to name guardians and all that, but it will generally be a pour-over will. It will essentially say, anything I forgot to title in the name of my revocable trust, please get it over into my revocable trust. But your main estate planning document is generally a revocable trust. And as the name implies, it is fully amendable. It is fully revocable. There might be trust and tax planning built into it, but just by virtue of titling assets in the name of your revocable trust, that's not necessarily tax planning, and there's not necessarily creditor protection. So that doesn't sound like it does a lot, but it's really two main things that are helpful from a revocable trust standpoint. Wills are public, right? So depending on the jurisdiction, people can go down and they can pull your will, and they can see maybe a list of assets, and they can see how those assets are distributed. A revocable trust, when you title assets in the name of your revocable trusts, revocable trusts are private. It's no longer a public document like a will is. Also, when you title assets in the name of your revocable trust, we get to avoid probate. So probate is when states get involved to administer the estate. It's when they oversee the process of distributing assets and are generally involved in the administration of the estate. Depending on the jurisdiction, that can be extremely costly and that can be extremely time consuming. It's generally something that we don't want. So the big deal with a revocable trust is in order to make it work, you got to title your assets into it. So maybe you have a brokerage account that was jointly titled, or maybe it was in your own name. It would now be the, Mr. and Mrs. Smith revocable trust, or the Mr. Smith, revocable trust. We would just change the title. It's a relatively easy thing to do, but it requires some administration to get the assets in the revocable trust. Again, it's fully amendable, fully revocable. It's basically a supercharged will. But I really need assets to be titled in there. Even though I have a backstop from my pour over will, they'll say anything I forgot to title in there, please pour it over to my revocable trust. We'll go through probate, on the way. So a revocable trust, I think our position is that if you can avoid even a de minimis amount of time and complexity and cost, particularly when emotions are running high, it's a really good thing to do. Even in Pennsylvania, it's a state where I spend a lot of time. Probate is pretty easy, right? And even there, folks still have revocable trust, to say nothing of other jurisdictions like New York and California and Massachusetts. It's a really good document to have, your revocable trust. So to round it out, so let me I'll give you the main estate planning documents that anybody should have, whether you're worth $1 million or worth $100 million. Everybody has their base estate planning documents. And that means how you take care of your stuff, which is your will and your revocable trust. But it also includes your ancillary documents as well. So a complete set of estate planning documents is a will, revocable trust, and these 3 ancillary documents: healthcare power of attorney, medical power of attorney, and healthcare directive, otherwise known as a living will. And I just kind of want to hit on those quickly because I think people forget about these as well. They can become dated and not operate the way you want them to operate. Just sort of take it from the top, you'll have a financial power of attorney, right? And this is all about who can step into your shoes from a financial standpoint if you're unable to make financial decisions, right? So if you're in a car wreck, you become incapacitated. Who can deal with creditors, right? Who can deal with financial institutions? Who can pay bills? Who can step into your shoes if you can't make decisions from yourself? But I would also say that I had a client a couple months ago. It was purely from a convenience standpoint. So I had a client who was abroad and he was trying to close on a piece of property back in the United States, and they needed wet ink at closing. They needed a signature to close on the property. He let his power of attorney know. His power of attorney showed up and said, I'm stepping into the shoes of the person trying to close the real estate deal, and they were able to effectuate the transaction. So a lot of times we say everything's fine till it's not. And I want to know somebody can act for me if I'm unable to act. But it can also just be very convenient sometimes, like, for instance, closing a property when you're not able to be somewhere. Let me jump one down to the bottom, healthcare power of attorney as well. Same thing. Who can make medical decisions for me if I'm unable to speak for myself? Who is able to get access to medical records if need be? It conveys my wishes. Do I want blood transfusions? Maybe, maybe not. What about certain surgeries? Yes or no? Experimental drugs, experimental procedures. When emotions are running high, when the thing has happened, you want somebody who is level-headed, who can point to a document, who can make decisions and convey your wishes when you're unable to convey them. So often we review documents and they are not the right person to do that. Or maybe they were the right person 5 years ago or 10 years ago, but people change and people move in and out of your life. And it's like a thing, it's just when you need it, you need it. And I need the right people in there. And kind of rounding it out, the middle one there, the living will, healthcare proxy. This is end of life measures, right? So this is, you are in a coma, you're not coming back, you were in a car accident, you're brain dead, purely end of life measures. And this can help with, when there's a lot of pain and emotions are running high as well. Do you want to be on a ventilator, right? If yes, no, maybe, how long? How about a feeding tube? Dialysis, do you want to donate your body? Do you want to donate your organs? So this is all to say that this is a complete set of estate planning documents: will, revocable trust, and your ancillary documents: healthcare power of attorney, medical power of attorney, healthcare directive. Do they say what you want them to say? Are there the key people named in these documents? So just a quick note that at some point, your assets are going to go down to your attended beneficiaries, nieces and nephews, or the kids, or whomever. I think our position generally is, and you kind of customize it and talk through what your options are, but our position is generally, I want these assets to go in trust for the benefit of, say, your kids. And there are a lot of distribution choices in terms of how you leave these assets, but trusts are generally the way to go for a few different reasons. So we'll talk about the tax side of things. It can be really good tax planning to leave assets in trust, and if it can go to the kids, it can go to the grandkids, it can go beyond. It's good, effective, long-term generational planning, but we'll get to that in a bit. One of the most important reasons why we leave assets in trust as well is the creditor protection, right? Purely asset protection. There could be other good reasons as well. There could be guardrails, and maybe the kids shouldn't have access, for instance, to a substantial amount of money at a very young age. You want them to have you want them to have motivation. So setting aside the guardrails, it's also from a creditor standpoint, because when assets are left in trust, there's a level of creditor protection. So assume the hypothetical of my wife and I are married and we're worth $20 million. And I have Jack and Benjamin, they're my kids, and let's assume they're adults. My wife and I pass away, and $10 million goes to each, Jack and Benjamin, and it goes outright, right? And let's assume they're married. And they begin to commingle those dollars, and they're raising the kids with them, and they're buying homes with them. They inadvertently or deliberately put those dollars in a joint bank account. If that marriage doesn't succeed, right, which tends to happen sometimes, at best, spouse is going to litigate that issue, right? And that can cause a lot of strife and cause a lot of money. And at worst, a heck of a lot of money can leave the family line. And it doesn't even have to be a spouse, which tends to be the biggest creditor that we see. It can be other financial creditors. They could get in a car wreck, or pick your reason why somebody may come after them, or just get a whiff they happen to have substantial dollars. Contrast that if I left the assets in trust for their benefit, right, where they can be trustee and they can be beneficiary, and maybe they have a co-trustee. In general, that is beyond the reach of creditors, right? They're not going to be able to reach into the trust because the kids don't own the assets. The trust owns the assets. So going from left to right, and I realize it's a busy side, so less creditor protection on the right and more creditor protection, less creditor protection on the left, more on the right. We see a lot of outright distributions. Our preference is to set the heirs up for success and leave the assets in trust. We also see a lot of the staggered distributions where it goes into trust, but at age 25, a third will pay out. At age 30, half of it will pay out. At age 35 or 40, the rest will pay out. Our preference is on the right-hand side, where you leave assets in trust, and this is a discretionary trust. I'm not forcing out income, right? I'm not forcing out principal. But if the beneficiaries need to take it, if they need to take the income, or they need to take a principal distribution, or if they wanted to buy something in trust as opposed to taking a distribution and buying it, they can do that. Trusts are useful tools, certainly from a tax standpoint, but also we think a lot about creditor protection, whether it's spouses, car wreck, or other financial creditors. It's a big deal in terms of how we look at trusts and what do the provisions say. So let me round it out real quick with, we talked about your base estate planning documents and how to maybe think about leaving assets to heirs. We have a lot of clients who are business owners, closely held business, they have real estate. And this is just a note to say that really that should be coordinated with your estate plan as well. So transferability of business interests, so maybe you want to do some gifting during life. Are you allowed to actually gift those assets? Or if you happen to want to leave these assets through your will to certain beneficiaries, are you allowed to do so? Do you have to leave it to other partners of the business? Can the kids have it? Can a non-family member inherit your business interest? You have to look at how you can actually leave your business interest, and that should be coordinated with your will, should be coordinated with your revocable trust, your main estate planning documents. Down below, your buy-sell agreement. I mean, I would think of this as your business will, right? I mean, in the event of death, disability, retirement, if the thing happens, if the triggering event happens, what happens to your business interest, right? So if I'm a business owner and I have a partner and I pass away for a number of reasons, I don't necessarily want my spouse to inherit a portion of the closely held business, right? Not only that, but my partner doesn't want to be partners with my spouse. So how do we think about actually buying out or turning that business interest into liquidity? Because that's what I want my kids to have, and that's what I want my spouse to have. I don't want them to necessarily have a portion of the business. Same thing in a buy sell, you're going to have a valuation clause. So if you do actually have to buy the business out, what's the valuation clause say? Did you stick it in a drawer when you did your shareholder agreement? Did you buy sell 20 years ago? What is the formula? Does that still make sense when emotions are running high? I want to know that everybody's on the same page in terms of how we're going to value the business. The partner is able to buy it out at a fair amount, and my family gets fair share for my portion of a closely held business, for instance. And then also, I think a question could become, how are you going to get the liquidity? So typically a buy sell is funded. So a given partner, if their partner passes away, there's either going to be cash or sufficient liquidity to buy them out. Maybe they're able to borrow to buy out the interest, but oftentimes it's typically an insurance policy. And maybe the two owners will insure themselves. They'll buy life insurance on each other, or sometimes the business will own the life insurance. So we have a dedicated liquidity pool to come in and grab assets and take some or all of the business. Also, top right hand, life insurance and estate taxes as well. When somebody has a closely held business, or we have big real estate families, it can get very challenging if you actually have to come up with the dollars to pay any estate tax, and you've got a bunch of illiquid assets like real estate. Typically, what we don't want to have to do is depend on selling those assets to cover any estate taxes. So maybe we'll have the liquidity on hand. Maybe we'll be able to borrow. Maybe you can sell some of the properties. But it's thinking about, is it insurance, or there's some other avenue to have the liquidity available if you actually need to cover some estate taxes. That can be a big deal with a lot of clients who have a fairly illiquid estate. And then finally, there can be a distinction when you have a business between management and ownership, right? Succession, right? How do you get value to maybe one kid who's in the business, and how do you get value and some level of control to the other person, the other kid who's working in the business? So that can be a really big deal in terms of how the asset actually flows and how somebody gets value and who's actually controlling the business. I reviewed a set of documents just a few months ago that called for the business to go to one kid because he was running the business, and then the other kid was going to be made whole with other assets in the state, real estate, marketable securities, all that. The problem was the business sold 3.5 years ago. Right. So you might imagine why that would be problematic if I'm looking at the documents to say one kid gets the business and the other kid gets everything else, but there's no business to be had. That's a problem. So this is all to say that it's a big asset. Things can get complex, particularly if family members and partners are in the business or it's an illiquid asset. You should give consideration to whether this is coordinated and how it's coordinated with your estate plan. So let's talk a little bit about taxes. So that's estate planning. Everybody should have it. There's a lot that goes into it. That was kind of the dime tour of what's important. Think about it as two parts of the tax code, right? I mean, we think about income taxes, that leaps to mind. And we have a lot of conversations around that, whether you're selling a business or you're having a big income tax year or an average income tax year. What are the strategies that we would think about bringing to bear to kind of mitigate an income tax hit in a given year, whether it's the federal level or whether it's state level? Really, we spend a lot of our time talking about wealth transfer taxes, and that's what really what I want to focus on here today is the wealth transfer regime. So I'm talking about the estate tax, the gift tax, the generation skipping transfer tax, right? I mean, how do we tax efficiently transfer wealth to the next generation? So I kind of want to level set on where the law is now. Let's talk about where it's going. That's a big deal for a lot of our clients, and exactly how to plan. What are some fundamental ways to plan around where the estate tax is going? So let's talk about the basics real quick. So we have a wealth transfer regime in this country, right? So we have an estate tax, which is a tax on your ability to transfer assets to the next generation. So it's typically paid before you transfer the assets, and then after you pay the estate tax, a net amount goes to wherever you want it to go. The estate tax rate is currently at 40%. The estate tax works part and parcel with the gift tax, because a long time ago, people figured out, well, if you're going to tax me on my assets when I pass away, why don't I just give them away during life, and I've avoided the estate tax. The gift tax was then put in place. It is also a 40% rate, and it works in tandem with the estate tax. I think the big deal for most clients is that bottom blue box on the left down there. It's the estate and gift tax exemption. So the regime works like this. There is an amount called your lifetime exemption And that amount currently in 2023, it'll tick up a little bit in 2024 in a few weeks. But the amount that you can shield from estate tax is $12.92 million, right? So that's the amount that can go tax-free, and anything above that amount is taxed at 40%. So if you take someone, a single person with a $30 million estate, they pass away, you get to back out your first $13 million, that gets you down to $17 million, and that's where the estate tax is applied times 40%. That's a $6.8 million estate tax, right? And that's cutting a check 9 months from the date of death. The challenge with that $12.92 million exemption is one of the reasons why we have this call is it's never been higher. But this increased exemption amount has a 7-year shelf life from when it took effect in 2018. On Jan 1, 2025, or at the end of 2025, when we wake up on January 1st, 2026, the exemption amount is going to be cut in half. So you'll have about half the amount that you have to plan with today. So take that same $30 million estate, and maybe you'll have only $7.5 million when you wake up on Jan 1, 2026. That leaves you exposed to $22.5 million times 40%. That's now, instead of 6.8, you're literally paying millions more. It's about a $9 million estate tax liability, and that's cutting a check 9 months from the date of death. So that's a big deal, and that's a lot of what we're here to talk about, is how do you capture sort of short game, long game? How do I use what the law gives me now? And then we'll talk a little bit about how do you let that appreciation sort of happen in trust as opposed to your balance sheet. I just want to touch quickly on the generation skipping transfer tax. The government really doesn't want you to pass assets from one generation onto the next generation and onto the next generation. So they implemented the generation skipping transfer tax that you can get it to the kids, but if you want to get it to the grandkids or it stays in trust, then there's going to be another 40% tax that applies. The government wants the ability for it to be taxed at parents' level. They want it to be in the kids' estate so they can apply the estate tax again. They want it to be in the grandkids' estate, and they want to apply that as well. Planning around this is critically important so you don't whittle away assets, but it's just another layer at a 40% rate that you have to plan around. Also, the generation skipping exemption is $12.92 million as well. There are also state considerations. So if you live in one of the 12 states or Washington, D.C., then you're going to have to plan around an additional layer of estate tax because some states levy their own. Still some other states, 6 states, levy an inheritance tax. So there's quite a bit going on from a legal standpoint. For those who are visual learners, we kind of put a graph out here for you to see. You can see where it increased. It went from 5.49 million to 2018. It sort of doubled the amount. And then you can see where we are right now in 2023, and then you can see where it's going to drop back down. We expect, adjusted for inflation, down there in 2026 to about 7.2 million. So that's a big deal for a lot of clients, but for us, that's opportunity because I can shield even more than I otherwise have been able to, but there's a window of time where we don't think we're going to be able to have that for much longer. So let's talk about that real quick. From a wealth transfer standpoint, I'd say the name of the game is how do we get assets into trust and how do we keep it there, right? So the question is how exactly do we get assets into trust and what variety of trust we're talking about. We're talking about an irrevocable trust. And the most fundamental way to get assets out of your estate is to gift them, right? And we're talking about a completed gift, right? We're relinquishing sufficient dominion and control over these assets. I'm getting them out of my estate, and typically we're gifting them into an irrevocable trust. Contrast this with a revocable trust, which is your main estate planning document. And once you've gotten the assets out of your estate, you've effectively sort of inoculated these dollars, right? Once you've gifted it away, you don't own them anymore. And I've used the exemption. And all subsequent appreciation happens outside of your estate as well. So if you gifted $1 million away, I've used $1 million of exemption. It's out of the wealth transfer regime. $1 million can turn into 2, 5, 10, 20, pick your number. It is all removed from the wealth transfer regime. So I kind of want to just talk about the fundamental basics, and I'll kind of cruise through these because I'm running a little over. So if you're going to gift shares, we want to talk about a couple things. Just for your own edification, I want assets that I can discount in value, right? And oftentimes those are assets that are in entities. It may be real estate. It may be closely held stock. I want to make precious use of my exemption. So if there are assets out there Closely held stock being an example where I can maybe recapitalize the business into voting and non-voting shares, and I can gift the non-voting shares. I can get discounts for lack of marketability, lack of control, non-voting interest. So maybe I can take $10 million worth of closely held stock and transfer $10 million in closely held stock, but maybe I only use about $7 or $6.5 million worth of exemption, right? I want to squeeze the value down of the things that I'm gifting, and valuation discounts are a really big deal in our world. And that's typically with real estate. That's typically with closely held stocks, things that are held in entities. And just a quick example, from a lifetime exemption standpoint, we note here, if you wanted to use your full lifetime exemption, and let's say this is real estate held in an entity or it's closely held stock, just based on a 33% discount, and the discounts can range from 20 to 40%, but call it a 1/3 discount, you could transfer somewhere around a little over $19 million in assets, discount that down, and then you've used your $12.92 million. So just using valuation discounts on day one, I've transferred millions more assets than I've otherwise been able to do. The way that you do this is you get a qualified appraisal, and then they will apply their formulas and they will apply their valuation discounts, and you'll file your gift tax return, and you'll have the appraisal attached to it, and that'll start the statute running. That's how you get your valuation discounts. That's how we think about it a lot when you're using your lifetime exemption. Permitted transfer review, we talked about it already. If I'm going to transfer any shares or any closely held stock or anything like that, I need to be able to do so, or I may need to amend the shareholder agreement or get some level of permission. Final point, I'll bring us home on this. So if I'm going to potentially gift assets, and you told me that you should do so in trust, what exactly does that mean? The trust isn't a revocable trust. This is an irrevocable trust. That's tax planning. That's creditor protection, irrevocable trust. So the most popular variety of irrevocable trust is called a spousal lifetime access trust. And this is typically used between married couples, or otherwise known as a SLAT, because everything needs an acronym in our business. And a SLAT goes like this. Husband, for instance, sets up a trust for the benefit of wife and uses lifetime exemption, however much you want. You can use the full 12.92 million or something less, and you gift those assets into trust for the benefit of spouse. So the reason why this is one of the most popular variety of irrevocable trusts is it allays the concern about gifting assets away and maintaining a level of access. Because husband is gifted assets away, but wife is trustee and beneficiary of the trust. I don't want them to depend on these assets, but pick your reason. If they wanted to take a distribution of income or take a distribution of principal, wife could and bring it back into the family economics. Husband has gifted assets away, uses exemption, got into an irrevocable trust, but still maintained a level of access to the assets. Lo and behold, wife can turn around and do the same thing. She could set up a spousal lifetime access trust for the benefit of husband, or husband can be trustee and beneficiary of his own trust. There's some technicals that you need to work around, but this is a well-worn path, and this is one of the most popular varieties of irrevocable trusts. We left an example here just to kind of illustrate the point of the growth, really. You put $12.92 million into a trust. We did some conservative growth rates of 3%. Maybe it's yielding 2.5%. And we showed principal distributions coming out. Normally, we wouldn't have principal distributions coming out, but we did it anyway just to show that you could. But the moment you put the $12.92 million in there, you've used what the law gives me, and it's not going to be clawed back. It's immediately out of your estate, but it's all the subsequent appreciation. And at the end of 35 years, all the growth, even with distributions, $43 million ends up to heirs. So it's really about short game, long game, right? Particularly with the law changing. How do I get assets into trust using the lifetime exemption that has never been higher, and then letting the subsequent appreciation happen in trust? Ideally in a trust where you can maintain some level of access for, pick your reason, if you were to ever need to access it. So maybe this is a good segue. We've been talking a lot about gifting. We've been talking a lot about planning. We've been talking a lot about trusts. And a key component, if you're going to have a trust, a big piece of the puzzle, because there are only three parties to a trust: the grantor who put the assets in, the beneficiary of the trust, and the trustee, which Katherine and Lisi are going to talk about, who takes legal ownership of the trust assets and is a critical role. Maybe I'll kick it to you, Lisi, Katherine.
Thanks, Jason. And thank you everyone online for joining us today. Really great to be speaking with all of you. So as Jason mentioned, today I'm going to be walking you through a really important decision that you'll face when you're putting together your estate plan. So now you've made this decision, you've spent the time on how you're going to utilize your exemption, you've relied on your advisors, your attorneys to put together an effective trust. You're going to be faced with the decision of, okay, who am I going to name to administer my assets as trustee? And for some, this can be a really easy decision. And for others, and many times for many individuals, this is a really complex decision that requires a lot of thought as to who you'll entrust to effectively administer the estate plan that you just took so much time and effort to create. So in order to understand what a trustee does, I think it's quite relevant to dive into a very brief, I promise brief, history lesson to understand how the concept of a trustee began and how that translates into what a trustee does today. So we'll take us back to 12th century England when landowners were called to fight in the Crusades. The landowner would quite literally leave his land to another person to essentially manage the property, to pay taxes and receive any duties that were owed on the land while he was fighting. And oftentimes the landowner would return and the person that he entrusted to oversee the land while he was gone would refuse to give it back to him. This meant that the crusader had to start a long process to petition the king, and oftentimes the king would rule in favor of the landowner. Now, eventually, this whole concept evolved into trust law, modern-day trust law. The crusader, the landowner, was considered the beneficiary, and the person to whom he conveyed the land to is the trustee. They were entrusted to oversee the property while the landowner was gone. Now, of course, we're not setting up trusts anymore today, at least I hope not, with the idea that we're going to leave it and go fight in a crusade. But the concept is still there, and I think it's very relevant to understand, okay, I have this person or an entity that I'm going to entrust to administer my assets according to the plan that I put together. So it becomes a really important decision. Who do I trust now for this job, and who do I trust for the future to do this job? So I'm sorry, I'm not up on my slides here. Let's go to the next one here. So legally, the trustee has a fiduciary responsibility and a duty to hold and administer the assets that you transfer into the trust in accordance with the trust terms. They effectively hold title to the property in the name of the trust. Now, practically speaking, how does that translate and what does that mean? Essentially, they're going to adhere to the literal terms of the trust. They're going to be making the distributions. They're going to be seeing that the beneficiaries are treated in an impartial manner. They're going to be signing account opening paperwork, filing taxes, and prudently managing the assets and investments. So not only are they going to be doing that during your lifetime, but if your trust is set up in a dynastical way, meaning it's set up to protect future generations down the line, they're going to be doing this far after your lifetime as well. So in most states in our country, you can choose either between an individual or an entity like a corporation, a trust company, or a financial institution to serve as your trustee. You'll hear the term corporate trustee, which is synonymous with the latter category there. Now, naming an individual on a trust is going to largely depend on the type of trust that you set up. So as Jason mentioned, these are irrevocable trusts. So it's really important to consult with your attorney as you're going through this process as to what requirements an individual might have in order to be able to serve on your trust. For example, they might not be able to be a family member. They might need to be independent to you. And a lot of times this can be largely tax-based and based on the type of tax planning that you've done in your trust, and state-specific as well. So please be careful and definitely consult with your attorney as you're going through that selection. But absent any specific circumstances, if you're going to have an individual serve on your trust, it's generally going to be less expensive than having a corporate trustee. And by having an individual, they're going to be a person. There's a human element to it. So they're likely going to know the family dynamics a little bit more and be a little bit more involved in the day-to-day relational aspects of being a trustee. But oftentimes this can be a downfall in and of itself because they are intimately aware of those family dynamics and they're human, they're susceptible to influence, of course. And this can also seem like a bit of a foreign language to people. Most people don't specialize in trust and don't have the expertise that are necessary in order to understand the duties that they may have to serve as a trustee on a trust. A lot of times this isn't their day job. They have another job and they can't devote the time and resources that are required to adequately be able to manage the trust in that impartial way that we discussed about for the benefit of your heirs and descendants. And lastly, unfortunately, none of us have found the fountain of youth. So who's going to be successor if something were to happen to the individual that you would name on a trustee, on a trust? So this is why many people choose to name a corporate trustee. So of course, a corporate trustee is certainly going to have costs associated with it that you wouldn't necessarily have with an individual. And depending on the type of formalities that a trust company or a corporate trustee has to follow, there may be a bit more red tape involved based on who they're regulated by, that's on a state or federal charter. But overall, you're definitely going to have an entity that all they do is trust administration. Their function is to quite literally administer the trust according to its terms. Corporate trustees have much more efficient processes from distributions, taxes, investments, and they're also much less susceptible to being influenced as to those family dynamics. And in order to be an effective corporate trustee, of course, you have to be aware of those dynamics. That's very important to properly administer a trust. But by having an entity in there, that entity is going to be far less susceptible to a decision being swayed as if it were to have an individual serving as trustee. Now, an example that we encounter quite a bit here is where a corporate trustee can really assist is when an individual was initially appointed on a trust, where you said, okay, my estate plan's in place, and for the time being while I'm around, I know that this individual is going to do a good job. I'm kind of here to oversee it, even though I've done the job of effectively doing that completed gift, giving away my assets to this trust. I'm still kind of here in the background to see what's happening. My concern is really when I'm not here, who's going to know my family, who's going to know what I want and be able to administer the assets in a way that provides for them. And that's really the key, and where the longevity of a corporate trustee like Rockefeller's can really have its benefits and provide those assurances for you and your family. So with that, I will turn it over to Lisi Madden to tell you a little bit more about some situations where a corporate trustee like Rockefeller can be a beneficial part of your estate planning.
Well, thank you so much, Katherine, for that great summary. And thank you to everyone on the line for taking the time to be with us during this hectic holiday season. So as Katherine outlined, there are clear benefits to having a professional trustee in place. And you've probably heard me say this before, but I like to summarize these as responsibility, liability, and saving family Thanksgiving. On the first point, the job can be a very big job that can require almost daily oversight and administration. On the second point, the job also comes with personal liability on the part of an individual trustee, which a lot of people don't realize. And we at RCM have a trustee liability insurance policy that covers all the individual fiduciaries with whom we work, which is pretty unique in the industry. And finally, as Katherine mentioned, having a professional trustee can absolutely help to mitigate family conflict, as well as to provide trustee continuity over multiple generations. So that means you may want to think about exploring a professional trustee for a number of reasons. First, if you paid good money and spent a substantial amount of brain power crafting a very complex estate plan, it's easy to forget that drafting the documents is step one. And to completely benefit from a great estate plan, you have to administer it properly after it's put in place, and this can be a lot of work. We've come across a lot of situations here where a trust comes to us after having been administered in, let's call it, subpar fashion, and necessitates a whole lot of triage once it comes in the door. And second, as families themselves grow and become more complex, having an objective, neutral, professional trustee in place for the long term can relieve close family and friends from having to navigate these responsibilities that can potentially embroil them in family conflict. And it can relieve them from potential liability. So maybe, as an example, someone serving as trustee is grandmother to an expanding brood of grandchildren and wants simply to enjoy spending time with all of these individuals who are beneficiaries instead of having to negotiate difficult distribution decisions with them. Going a bit further, and at the risk of getting a bit darker, I'll share one real live cautionary case study that's out there. Children sued mom, trustee, for breach of fiduciary duty. During the dispute, mom stepped down as trustee, and one of her daughters petitioned for appointment as successor. And mom introduced evidence of daughter's past psychological and medical issues in court in opposition to her daughter's appointment and support of an appointment of an independent trustee. And the case attracted widespread media attention and actually resulted in mom's alienation from all but one of her children. Now, all that said, during my prior life at a law firm, I definitely saw clients struggle with big banks as corporate fiduciaries in a lot of cases. The struggle was real, and it mostly related to all the administrative red tape and employee turnover and the impersonal, mechanized attitude towards a relationship that should be anything but. Trust involved families, and as we know, families are different, and most have sensitive issues that clients need to feel comfortable discussing with their trustee. So this is why it's important to not just choose any professional trustee, but to choose the right professional trustee for you and your family. And I will say humbly, or maybe not so humbly, that the Rockefeller Trust Companies will be the right choice most each and every time. And here's why I feel that way. We can provide the professional level of service necessary to do the job of trustee well. But we started in order to service a limited number of families. We were not started by a big bank in order to service big bank clients. So quite simply, our DNA is different. And this history, along with our relatively small size, means that we are nimble enough to be able to provide customized, responsive, user-friendly service that is necessary in this area. We have two trust companies. We have the Rockefeller Trust Company NA, which is a national banking association based in New York City. And we have the Rockefeller Trust Company Delaware, which is a Delaware-based trust company in Wilmington. And either one of these trust companies could serve as sole trustee, co-trustee alongside individual trustees, or as agent to individual trustees. And the Rockefeller Trust Company Delaware can also serve as a directed trustee or as an administrative trustee as well, roles that are available under the laws of certain states only, one of which is Delaware. We have seasoned trust professionals across both trust companies who are skilled at navigating families through what can be a real maze of an estate planning world at times. So I will leave you with just one message before I turn it over to Mr. Laffey. If you have or are thinking of having trust in your life, and after listening to Jason and Tim, you may be running out to get one, then think of the Rockefeller Trust Companies and please reach out to me or to Katherine at any time. So thank you again and have a wonderful holiday, everybody.
Thank you, Lisi, and thank you everyone for joining the call today. I really appreciate it. I know we're starting to get a little short on time, but so I'll be going through some of this quickly, but I did want to point you to a year-end tax planning piece that the Wealth Strategy team and myself put out that was released on November 30th. That covers a lot of these concepts in much more detail. So I'll start, given that a lot of the discussion today was around the transfer tax. That's where I'll start right now quickly. Really want to cover three things here. First and foremost, use the low-hanging fruit that the IRS gives you. There are certain types of gifts and transfers that will not count against that $12.92 million exemption amount. The first one I think most people have heard of as the annual exclusion. So for 2023, each person can give $17,000 to an unlimited number of individuals, and that $17,000 will not count against their $12.92 million. That amount is scheduled to go up to $18,000 per person or $36,000 per person in 2024. Couple unique strategies there that I think I'll mention. Sticking with the trusts and the tax planning and asset planning that Jason talked about, there are trusts called crummy trusts that are set up to receive annual exclusion gifts. So if you're hesitant to give these gifts because you think your beneficiaries might spend it down or use it recklessly, there are trusts that qualify for the annual exclusion that we can talk more about. Other things, if the potential beneficiary you're thinking of has earned income, think about jumpstarting a Roth 401k, a Roth IRA for that individual. And then last but not least, certainly 529 plans. You can supercharge a 529 plan by funding 5 years of annual exclusion gifts for a beneficiary. Next thing in the low-hanging fruit is the direct tuition and medical expenses. So the IRS doesn't even treat these as gifts. So as long as you make the payment directly to the educational institution or the medical provider, that does not count against your $12.92 million, and it also doesn't count against the $17,000 annual exclusion cap. So you can make these in an unlimited amount to an unlimited number of individuals at any time of the year. Second thing, and this is something we touched on, Jason touched on a lot today, but use that bonus amount that the IRS has given you to the end of 2025. I know we're getting a lot of questions about could this potentially be extended, and we don't have that crystal ball. So I think it is very important to think that, at least go into thinking that it is going to go away at the end of 2025. A couple things that you can be strategic with there. If you're gifting assets that are not marketable, so not cash or marketable securities, you generally do need a qualified appraisal, and those appraisals do cost money. So you can be strategic there and potentially get one appraisal towards the end of the year, use it for your 2023 gifts, and then use it again in 2024 for gifting in January, early February, and take advantage of that additional exemption amount we're getting. Other thing is the way the gift tax value is determined for marketable securities. It's the mean of the high and the low on the date of the gift. So in a relatively volatile market that we see these days, you can be strategic about your gifting of publicly traded securities. On the wealth transfer planning front, most people think that when you're in a higher rate environment, it's not ideal for wealth transfer. And that is generally true for a lot of the strategies we see. But there are two strategies that actually work better when we are in this higher rate environment. First one is a qualified personal residence trust. I won't get into all the details, but long and short of it is, as the interest rate gets higher, the amount of gift tax exemption that you have to use to set up this strategy goes down. And the second one is a charitable remainder trust. With that, as the interest rates go higher, basically the income tax charitable deduction that you get for this type of strategy increases as well. So jumping over to the income tax side of things. So I think most are familiar with tax loss harvesting, so I won't spend a lot of time there. I will mention opportunity zone opportunities. Basically, that's the ability to defer capital gains until the end of 2026. The general rule is that you have 180 days from the date of the capital gain to put your money into one of these opportunity zones and defer that gain. But there is a special rule if you realize the capital gain through a pass-through entity, such as a partnership or an S-corp. Basically, if the capital gain is coming through one of those, you actually have basically until March of 2024 to defer, to start that 180-day period and defer that gain. Next one, charitable planning, bunching charitable deductions. So I think, as most people know, we're under the Tax Cut and Jobs Act, we have a much higher standard deduction, $27,700 for 2023. Also, the state and local tax deduction is limited to $10,000. So long story short, there's a lot of people that, if they're doing their standard charitable contributions, they may not even be exceeding that standard deduction and getting any benefit for their charitable gifting. So it may make sense to bunch multiple years of charitable deductions into 1 year, and you can utilize a donor advised fund to do that. I'll touch on non-grantor trust planning before I skip to the next page. But as Jason was talking about, a lot of trusts being grantor trust and non-grantor trust. A non-grantor trust is a trust where the trust itself generally pays the tax unless the income is distributed out to the beneficiary. And the non-grantor trust reaches the top 37% tax bracket at $14,450 of taxable income versus $693,000 for a married couple. So if the trust has discretionary distribution provisions like Jason talked about, there's an opportunity to do some real tax planning between the trust beneficiaries and the trust itself. And that 65-day rule, I'll close this out with, is basically that allows any distribution from the trust up until March 6th of 2024 to be treated as a distribution for 2023 for tax purposes. So I know I only have a couple minutes left here, so I just want to talk about a couple retirement and IRA planning things. Make sure you're getting your RMDs done for the year if you are subject to them. There have been a lot of changes in those rules. It is with the recent market volatility, there's a potential that a Roth conversion could make sense. That's especially true given that the 39% tax bracket is going to return in 2026. And then qualified charitable distributions. If you have clients or you're a client that's age 70 and a half, you can start making these charitable distributions straight out of your IRA, and it will satisfy your RMD. It will not hit your taxable income, and it will give you the ability to benefit from your charitable giving without having to itemize your deductions. So there's one last page with some business planning tips. They'll cover a lot more detail in the year-end tax planning piece I mentioned. So I think we have a couple minutes left. Any questions, Katherine? I know you're monitoring them.
Yeah, definitely. So this is a common question that has seemed to pop up in a couple iterations, but are the changes to the exemption amounts dependent upon the 2024 election?
Yeah, I can take that one, Katherine. And it's a great question. Definitely one we get a lot. As I mentioned earlier, I wish we had that crystal ball, but I do think the one thing you can guarantee about politics, especially the current political environment we're in, is that there are not any guarantees whatsoever. Even if there is a red wave, kind of like the blue wave of 2020, there's no guarantee anything substantial gets done. Just like the Democrats, their broad tax reform proposals, not meant to ever happen. So even if there is the red wave, and most people are thinking if there is, then potentially we get an extension of this, I just think it's a little uncertain. But I do, at the end of the day, I think we have to plan for what we know today. And that really is without legislation being passed before the end of 2025. When we wake up on January 1st, 2026, that exemption amount is going to be cut in half.
Certainly. Yeah, great advice. And as we've seen that the exemption levels and grantor trust, all of this type of planning that you utilize is seen as low-hanging fruit, but we've kind of been in a cyclical pattern as to trying to guess what's going to happen. So certainly great advice. And with that, I think we're at time here. So I'd like to thank you all so much for tuning in today. We really appreciate it. If you have any questions, please feel free to reach out to any one of us or your Rockefeller advisor. And with that, we wish you a very happy holiday season. Take care.
Thank you.